Hi friends, welcome to Active Self-Protection Extra. Today here with renowned internet attorney James Reeves from TFB TV. And I want to talk a little bit today about the Ahmaud Arbery verdicts and talk to an attorney that does self-defense cases for a living about the differences between this case and the Rittenhouse case.
Now more than ever, you need trusted coverage to help you win the fight after the fight. The company I trust and recommend is Firearms Legal Protection. They offer discounts on all their plans at the link in the description. I recommend the premium plan.
So James, I don't know that many people know, they know you from TFB TV, right? You're talking about guns and stuff on the old interwebs, but you are a practicing criminal defense attorney.
Yeah, do it. That's my day job.
And not only that, but really specializing in self-defense in a lot of cases.
Yeah, and it's funny though, those aren't necessarily the best paying cases. So I do
you gotta
a little
spread
some of
that
that
case a little bit.
Well, and contractual litigation is really where I got my start for the first 13. I've been practicing for 13 years now. I want to say since 2008, 14 years.
Wow.
And that's really how I got my start. But then it started evolving. Because people are like, hey, you're a gun guy and you're a lawyer. It seems like you would be a natural fit for this. And really knowing gun laws, which is what we're going to talk about today, it actually gets you very far. In fact, further than not coming from a con crim pro background, not coming from a DA's office, just starting as a civil litigator, getting into it, knowing the law is what's really important, not only for attorneys but for your viewers out there.
Sure. Okay, so I'm sure you know the case by now that Gregory and Travis McMichael and William Roddy Bryan were all convicted of felony murder and some convictions of malice murder, which is a different thing in the state of Georgia, for killing Ahmaud Arbery. And you can go and watch the main channel. We'll put a link in the description to the analysis of those events. But I wanted to talk to James a little bit about the big differences that he sees here. Now, I'm going to tell you, just like we talk about this all the time here on John's Briefs, we don't talk through all this, and I haven't tossed him softballs and said, I want you to say this, that, or the other thing. That's not how we do things.
You ambush me. I hate it. He puts me on the spot.
Yeah,
it's a challenge.
So obviously you watched the case.
Yeah.
And I think we had two cases side by side, both litigated in public the whole way through, which is very eye-opening for a lot of people. What was the big thing that you think made the jury decide to convict?
Well, you're really looking at cases that are the converse of each other, or the inverse rather, where you have Rittenhouse, who used a gun to defend himself while he was fleeing from attackers. Where in the Arbery case, you had Mr. Arbery, who was fleeing attackers who then used a firearm on him while he was fleeing, more or less, confronted him, and they were the aggressors, as we call them in Louisiana. There's the aggressor doctrine. So to me, the facts shook out, and the jury interpreted the facts, because again, there were two different interpretations, one presented by the prosecution, one presented by the defense, that we can go into in a little bit more detail. But the jury interpreted that as essentially they were pursuing this man, not maybe with the intent to murder him, but that was how the facts shook out in that case, where with Rittenhouse, quite clearly, he was defending himself. I mean, I thought, I'm not sure if this is appropriate, for your channel to hear that lawyers talk like this, but I was at a bench and bar conference with a bunch of other lawyers and judges, and, we were having a couple drinks, after a day at work. We're talking about the case, and a lot of people were really upset, really outside of the gun community, about the Rittenhouse verdict and about how that case was shaking down. The verdict hadn't been delivered yet, but it was during deliberations. I'm at this bench and bar conference, and there are lawyers saying, that kid, he should go to jail. And I said, look, how about this? I will bet anyone here right now $100 that kid does not get pegged with a felony. No one took me up on it.
So it's funny.
No. I wish. I said $100. Like we're a group of 6, 7, 8 people. I'll bet every single one of you $100. No one took me up on it. So there were a lot of feelings. Both cases were very evocative. They were both very evocative. But it's quite clear from the facts and the jury's interpretation of the facts that it seemed that the Arbery killing, it was these 3 men who were somewhat foolishly pursuing...
The provokers and aggressors.
Yes, they were the aggressors, and you are not going to be able to raise self-defense as a legal defense in any state, to my knowledge, if you are the aggressor. And if they peg you with that.
So it seems to be the defense said that, okay, so they thought that he might have been matching the description of a guy who they thought had committed some burglaries in the neighborhood. And so they decided to pursue him. Now, some folks are saying, oh, it's legal for them to make a citizen's arrest. Well, but even if you read the statute in Georgia at the time, it was only if they knew that he was fleeing after a felony, which they didn't know. They said he looked like a guy who. And so that, their own admission there was a big deal. And then I think the defense's biggest argument was that he got the shotgun out because he was trying to stop Arbery and was worried that Arbery might try to hurt him. But that having a gun in hand was a provoking incident.
Oh, I mean, that's assault in virtually every state. I mean, aggravated assault in most states to just present a firearm in that particular scenario. So, the way you say it, of course, is not how the defense said it. That is a fair recitation of the defense's argument. But more or less what they wanted to say is, look, there's a Georgia law, and there are laws like this in most states where you can, citizen's arrest, right? That's what they call it colloquially, citizen's arrest, where if you see someone committing a felony, you can detain them.
Yes.
And there are statutes that allow you to do that. As a liability lawyer, on the liability side of things, as a civil litigator, that terrifies me. To think of the average citizen stopping someone, detaining someone. Now, certainly there are instances where that's warranted.
You see somebody, that is kidnapping someone else.
Right.
You got to stop them from doing
Right, and I would advise that you be extremely cautious and avoid those situations under all circumstances if you can.
If you can.
Mean, if it truly seems like you need to intervene to maybe stop. In some states, you can't even use deadly force to stop a property crime. Right? So if
most states, everywhere except for Texas, in very limited instances, pretty much.
Right, sure. So
be cautious.
So I advise that people think very hard before they get into that themselves into that sort of situation, because what ends up happening is you have what happened with the Arbery case, where the guy was jogging, and to step back a little bit, the defense's argument was, look, they know that there were these house burglaries. This man matched the description of the person who was committing the burglary.
Sure seemed like as much of the description he matched was he was young and black.
But sure, and and that actually could be passable in some instances. Now, I mean, they chased the guy down and shot him, but I could certainly see if the facts were different, where they say, hey, look, he was a young black man. There was a young black man who was robbing buildings. Fair enough. However. And as it turns out, right, he went into a building, I believe.
He did. They had video of him inside of a house under construction, but they did have video of about 5 or 6 other people going into that house.
Sure. But that said, I can see how the defense said this is a plausible argument, right? Like the guy, yes, he's a young black man. He matches a description. He was in a house. So we decided that we were going to interject ourselves into this situation, be the cops for our neighborhood. We were going to round the boys up, get a posse together, chase this guy down, pursue him, and then try to detain him using the fear of violence, of death or great bodily harm. So to me, that's unwise to begin with. If I saw somebody, John, I love you to death. If I saw someone robbing your house, I'd call the cops.
Yeah, absolutely.
I'm not sure that I would go. Even you have to think of it from a civil liability aspect too, because let's say hypothetically they beat this case, because I don't think they were charged for maybe months,
We're going to talk about
months.
this in another video, but yes, it was months.
Yeah, and they weren't charged. So for me, I see that as a bit of a red flag, right? Where you have these guys that. Sorry, I lost my train of thought.
So you said he wasn't charged. So.
Oh yeah. So yeah. In any event, sorry about that. So apparently there was somebody out there that thought what these guys did in law enforcement. I believe even you had a DA who recused himself, who wrote a letter, and he said, "Look, from my perspective, these guys did nothing wrong." And that. Let's say they beat those charges.
Right.
Well, then they get sued.
Right.
Civilly.
There's a civil liability.
Correct. And then remember, you're not talking about beyond a reasonable doubt. Now you're talking about preponderance of the evidence.
That's right.
50.0000001%. If you think that they did it, if you think that what they did, if the jury thinks that it was wrong,
Yep.
more or less, to oversimplify it, then you're going to pay a substantial amount of money. We're talking, for how old was Arbery? He was a younger guy.
Yeah, young guy.
Yeah, younger guy. I mean, that could be upwards of $1 million just for the civil verdict. So you have to think about these, not only the criminal consequences, but by God, the civil consequences can be tremendous if you don't think this through before you do what these men did.
So it seems to me that the big legal principle here was, why was Kyle Rittenhouse acquitted? So that the prosecutor could not prove that he had provoked the encounter, and he was running away. And so when he's running away and this person then presented a threat of death or great bodily harm to him, he's justified to use deadly force to protect himself. In the Arbery case, on the other hand, the McMichaels, they were the pursuers. He was running away, and so they provoked the very attack that they were in. And in any case, you cannot use deadly force to protect yourself if you provoke the encounter.
Sure.
And they chased him for miles. They didn't just see him and it was this immediate thing where they're like, whoa, what's happening? No, they chased him, they cut him off, they ran apart from him, they did this other stuff. And so I honestly think the lesson in both cases is the same. Don't chase people.
Sure, but it's quite simple. I mean, it is a straight up aggressor doctrine case where if you are the aggressor, you cannot claim, because what they said is, look, I was in fear for I defended myself. Well, when you put yourself in the situation where you have to defend yourself, that means that you're the aggressor, right? So they were the aggressors. They can't raise self-defense as a legal defense, and that is why that case was completely different than the Rittenhouse case.
There you go, guys. Don't be the aggressor. Now, again, I know there's going to be comments. I know people are going to say, yeah, but they had the right to. The unwisdom, the lack of wisdom, the stupidity of chasing this guy for miles, of being the cops and saying, no, we got to stop this kind of thing happening in our neighborhood. Then they provoke the attack and Arbery was trying to get away, cuts off his retreat. Arbery reasonably made the choice in that minute. I got to stop this guy and get into a fight with him because he's going to shoot me with a shotgun. It didn't go Arbery's way. And I think that, if it had gone his way, if he had taken that gun away, well, he had the other guy with the gun too, I think he would have been justified to use it in defending his own life. So I think that's the big difference. The person in flight is almost always seen as the victim here. So, and listen to what James says here. Even if you legally could have got away with it, which they probably could have if they hadn't released the video, I think that it's unwise in the extreme to do so. Next time, I'm going to talk to James about why William Roddy Bryan was convicted of murder when he was on the cell phone. James, appreciate the knowledge, man.